Welcome to We Are Old, Get Over It, the podcast where we celebrate the wisdom of age and maybe a little grumbling too. Okay, so we're going to go ahead and start. First of all, I want to welcome you to the podcast. I'm going to introduce you in a second, but I want to welcome our guests and our audience to the podcast also. All two of you, no, I'm just kidding. Whoever is out there listening to us today or forever in the future, because it's broadcast quite a bit right now. Okay, so today, let me find my notes because I was so busy taking them away from you. Okay. So today we're tackling a topic that many people shy away from, one that is incredibly important for peace of mind and protecting your wishes, living wills, and advanced directives. We have a fantastic guest. I haven't known him for long, but I've known him long enough to know that he has a great sense of humor, and he's put up with people worse than me, which is amazing in itself. What I'd like to do with the podcast is do two things. I'd like to do an introduction for you, but before that, I want to just read a quick quote, which will kind of put us in the place that we're going to be going to. This quote is from the Mayo Clinic. I didn't know there was a person named the Mayo Clinic, but that's the quote that I got from AI about this. By planning ahead, you can get the medical care you want and avoid unnecessary suffering. You also can relieve caregivers of decision-making burdens during times of crisis or grief. You agree with that one?
Of course. I
Okay.
think that if you don't plan ahead, you're really leaving it up to organic decision making by a group of people who may not have known or been given advance notice of the need to make collective decisions, and who may not agree on what direction they ought to go in on behalf of a now incapacitated individual. And we all know that if you take a few people and they're sort of tied at the hip, but they all start going in different directions, not a whole lot
Hmm.
happens, does it?
No, only tearing apart. That's it. Anyway, let me introduce you first of all. Your name is Howard Krooks. Uh, I'm going to call you Howie because I think that's what your parents probably called you, right?
Yeah, well, amongst many other things, yes.
Well, my parents used to call me Kenny, but everybody kind of calls me Ken except my family. Uh, now, I have a question. I have you listed as an elder law attorney certified by the National Elder Law Foundation and a member of the National Academy of Elder Law Attorneys. You have extensive experience in estate planning, including the creation of living wills and healthcare proxies. I have one question before I'm going to let you take over. Are you an elder? Do you have to become an elder to become an elder lawyer? What is
Elder
that?
law attorneys run the gamut from very, very young, fresh out of law school, all the way into 60s, 70s, 80s. I'm not sure I know of anybody in their 90s still practicing, but it may be out there.
Okay. And I did a search because I wanted to find someone who was an expert. And I asked in my searches for the top 10 people in the United States that we should speak to. And you were the first one that responded back to me. Actually, no, there was one other one, Rebecca Suter. Do you know her?
I don't know, Rebecca, but I can submit to you that that may not be so good that I was the first one to respond to you, because it means I
No, but I
obviously
already had your
don't have very
information.
much
So,
work to do. And maybe I'm not the best one to be on the show, but
well,
what can I
we'll
do?
find out because from now on, you're going to do most of the speaking and I'm just going to do the in betweens. Okay. So go ahead, Howard, and just go ahead and lay this on me, what it is that you're going to be speaking about today. And we'll just go right from there. Okay.
Of course. Yeah.
All
So
right. Go ahead.
I think you mentioned the term advanced directives. You've mentioned some specific ones: healthcare proxy, living will. Let me just make sure everybody's aware of what an advanced directive is. It is your set of instructions as to what somebody else should do on your behalf if you're no longer able to make decisions on your own. Okay. So they're advanced directives of your wishes, and they could pertain either to financial decision making on the one hand or healthcare decision making on the other hand. And there are a variety of documents that your audience may have heard of that would fit within this overall category of advanced directives. So, for example, a durable power of attorney. Many people have heard of that. A healthcare surrogate, a healthcare proxy. I'm sure people have heard of that. Living will. HIPAA document, Health Insurance Portability and Accountability Act of 1996, which is a privacy federal act that classifies protected health information and says to a healthcare provider, you can't just give that information out to just anybody. They have to have an official capacity. They have to be appointed as a designated representative to receive that kind of confidential and otherwise protected health information. So these are the kinds of documents that we're talking about when we use the umbrella term advanced directives. And
Okay.
it's really important because I think people would understand that, somebody handling their financial affairs under a durable power of attorney, it's extremely important that they only appoint somebody that they trust, because this is somebody that once you sign the power of attorney and you give them the authority to manage your affairs, your financial affairs, that is an all-encompassing document. And some of them are drafted very broadly. For example, it would allow the agent under the power of attorney to go to the bank and withdraw money from your bank account. Really? What? What if I don't want them to? Well, then you shouldn't appoint that agent if you don't trust them not to do something that you don't want them to do. On the other hand, if it requires them to pay bills and you cannot pay your own bills, it's really good that you have that, right? Because they can access your accounts, they can speak to third party vendors, they can talk to the electric company, they can talk to any one of your vendors, and they can get information about billing. They can question your bills. They have the legal authority to deal with third parties. They have the legal authority to contract on your behalf, legal authority to talk to insurance companies, the Internal Revenue Service, various government agencies, the Social Security Administration, Medicare, Medicaid, you name it, a Veterans Administration. They will have the authority to do anything that you could do in a power of attorney. So, on the one hand, it's extremely useful. And on the other hand, it could be extremely harmful if you don't choose the right people to act. Similarly, on the healthcare side, if you, if there's an important medical decision that needs to be made, who do you want making that decision? It could be as simple as what type of medication should be administered. Is it going to be generic or name brand? It could be a decision as to whether or not you will undergo a certain medical procedure, which may or may not be life threatening. And so, whoever you appoint for healthcare decisions is also very, very important, because your own health and possibly your life could depend upon any one of the decisions that are made on the healthcare side.
You mentioned two things. One's more about monetary things, and the other one is more about personal health issues. Um, would you? I'm not going to ask for your recommendation, but maybe just from your experience, who is best to handle each of those? Because it probably isn't the same person. Would it
Well,
be
so,
a son or a daughter
I
or a
can't have
spouse?
right, okay. So I was gonna say, I always hesitate to say, quote unquote, "It depends," because right, because 'cause I'm a lawyer, right? So it just
Mhm.
depends. But but if you're evaluating who it should be, then those are all logical choices, right? A spouse, a son or a daughter. Some people may have friends that they rely upon. Some people don't have a spouse. Some people don't have kids. So it's not always spouse and kids, but those are certainly logical go-to people. And they're also, in some cases, not appropriate to serve. Unfortunately, there are spouses and children who are not trustworthy or deemed to be trustworthy by the person making out the document, right? So it's very challenging for some people to select who their agents are going to be, but it is a core component of these documents. In other words, if you don't have somebody that you can appoint, then you're not really going to be able to do these documents at all, unless you can tap somebody who's like a professional who's willing to serve on your behalf. Maybe you have a long-standing relationship with a professional and they're willing to serve, or it's just a longtime friend that you have. But you do need at least, I would say, two people that you can name in these documents. Why do I say two? If you only appoint one, then the value of the document, the value of the appointment is limited in a sense to the longevity and willingness to serve of the person named. And so it's always recommended and a good idea to name at least two people. They don't have to be authorized to serve at the same time, but they can be authorized to act in succession. So you have your primary person, and only if that person cannot serve, then the successor person steps into their shoes and begins making decisions on your behalf. So that would be a minimum requirement for me. It's been very rare in my 30 plus year career that I've allowed a client to sign these documents with only one agent. And that simply being because they said, I'm sorry, but beyond that one agent, I have nobody that I can or am willing to appoint. So in that circumstance, my thought process was, well, better to have these documents with somebody named than to not have them at all, right? But other than that, outside of that, 99% of the advanced directives that I prepare have at least two and sometimes three, four, and five people named.
Really? Okay. I'm sorry. I just wanted to ask that question, and I'm glad you gave me such a nice answer, a good answer.
Yeah, of course. So let's dive a little bit deeper into who should be chosen. It may very well be that people in your life, some of them are better suited to make financial decisions, and others might be better suited to make healthcare decisions, right? And are not very financially savvy. So in that case, it's more than appropriate to say the person in my life who's very financially savvy and whom I trust, you're going to be appointed under my durable power of attorney. And the person who is more in tune with what my wishes would be on the healthcare side, you're going to be my healthcare proxy, my healthcare surrogate. You're going to make decisions about whether I want life sustaining treatment if I'm in an end of life treatment scenario, and those could be absolutely different people. So you really need to think through your agents, your fiduciary appointments, and select a person that's better suited. Um, I'll give you an example though where it can go awry. If you have the person who's more financially savvy, but who may not make financial decisions that are in your best interests, but rather financial decisions that are in their best interests, then that may knock them out, even though they're perfectly capable of being named as your agent. And the example I would give you is a perhaps child who views your money as their inheritance as opposed to your money that's there to help you in a time of need. And there could be resistance to spending that money on your behalf in ways that would absolutely improve your quality of life and be to your benefit. If you have somebody like that, even if they are more than capable financially of understanding what needs to be done and effective at carrying out what needs to be done, they may not be an appropriate appointment for you for that reason, right?
I
So
understand.
there are lots of considerations that go into your choice as to who will serve. And one other point that I would make here, Ken, is that I would compare it to making out a will, where if you have a certain number of children and if you want to leave an equal amount of assets to each child, which is a fairly typical estate planning concept, right? I want to treat my kids equally. I would submit for consideration anybody who's doing these documents that when it comes to appointments for advanced directives, you don't necessarily need to or want to treat your kids equally. Why? Because this is all about you, not them. And this is not a distribution of assets. Think about the import of the decision making that has to go on at a point in time when you will no longer be able to guide the appointee. You'll no longer be able to give input into the decision. They have to know you well. They have to know what you would have decided to do. They have to step into your shoes in that way. And they have to also be willing to put their personal feelings aside and only act in your best interests. So, this is not a situation where if you have four children, you have to appoint all four of them. with equal decision-making authority. This is a situation where you need to get past that and you need to really think about it. And you'll know, by the way, everybody knows in their gut who's better suited than another, and even in their immediate family. And my advice would simply be to go with that gut feeling about who is going to be best suited to carry out your financial decision making on the one hand, your healthcare decision making on the other, and without regard to the quality of treatment that typically is helpful in the estate planning side of things. Let me make a distinction, if I may, between the healthcare proxy and the living will. So, the healthcare proxy is a document that names another individual to make any and all healthcare decisions. Okay, if that's true, why do we need a living will? Why is there another healthcare decision making document? And the answer to that is as follows. Any and all healthcare decision making is from the smallest decision about what I said earlier. Will I ask for a generic brand or a name brand drug be prescribed to a medical procedure, even if it's not very serious, whatever the case may be. But living will is only applicable to a specific point in time. And that point in time is when a person has developed a terminal condition, their prognosis is likely to die within some period of time. Usually it's 3 to 6 months. Their quality of life is very low. They're either comatose or in a persistent vegetative state. Certainly they're non-communicative or highly enough confused that they cannot make their own decisions and provide informed consent. And according to the doctors, this condition is not likely to reverse itself. It's improbable that there'll be a recovery here and this person will no longer be considered terminal and die. So that brings us into an end of life treatment scenario, which is the only time that the living will applies. The healthcare surrogate, the healthcare proxy, those are two different names for the same kind of a document, which applies to all medical decision making. That could apply for years, decades even. The end of life treatment scenario is probably short lived, and it truly is at end of life. So that's really when that document, the living will, gets triggered. And the kinds of decisions that it authorizes for the person that you name in your living will is whether or not life sustaining measures ought to be implemented on your behalf. For example, if you are comatose but you suffer a heart attack, do you want to receive cardiopulmonary resuscitation? Yes or no? If receiving cardiopulmonary resuscitation only puts you back in the place you were before the heart attack, would you want to receive that kind of resuscitation? Or would you want to be allowed to die naturally? That's the decision that you need to make when you sign this document with instructions to your agent to communicate those instructions. Do you want to receive artificial nutrition and hydration? Yes or no? Remember, without it, you will probably die in a short period of time. Do you want to receive experimental medical treatment? If you're dying and you're diagnosed as terminal, do you really want experimental treatment to try to see if it'll get you better? Yes or no? So those are usually questions that all receive consistent answers. If you don't want CPR, you also don't want nutrition and hydration, and you also don't want experimental medical treatment. On the other
Of
hand,
course.
if you are the school of thought that I don't care if I'm terminal, and I don't care if the doctor says it's irreversible, I believe in miracles, and under no circumstances do I want any of that stuff withheld because you never know, then you will ask your attorney to prepare a document that says that. Now, that is the minority position, not the majority position. Neither one is right or wrong. Each one of us is individuals, each one of us from our own life experiences and what we feel about this issue will dictate what our wishes are. And that's the purpose of these documents, to have your wishes set down in writing and to have a declarant and an agent who can effectively communicate those wishes to a third party, a healthcare provider, so that those wishes can be followed. And these are legal documents. There are statutes in every state Sometimes living wills are only recognized by common law, but there are certainly healthcare proxies in every state in the country. And you should probably know that. So now I've got myself sort of segued into a new issue, which is suppose I spend time between two states or maybe two or three states.
I was gonna ask you about that, actually, about what happens if you decide to move to from Florida, which is where you and I are, but you decide you wanna live in Las Vegas. Let's not use Las Vegas as an example because I don't know what the laws are there, but just say some other state. I think that's important for you to bring up.
Sure. So as it happens, why don't we do this? Because I practice in Florida, as you said, I practice in New York, and I practice in Pennsylvania.
Okay.
So in dealing with those three jurisdictions, I tell my clients who have connections to more than one, you should do documents in both jurisdictions. Why? Well, many people spend half the year in Florida, half the year in New York, half the year in Florida, half the year in Pennsylvania, etc. If your documents are invoked, meaning that you're lacking in decision making abilities and therefore your advanced directives, your agent needs to communicate on your behalf. While it is true that in most states, your out of state documents are to be honored in the other state. So let's say I had Florida documents, but the person was now in their New York residence, and then something happened while they were there. Could they proffer their Florida documents and request that a healthcare provider in New York honor their out of state Florida documents? Yes, they can do that. And New York even has a statute that says out of state documents properly executed in the home state must be honored here in New York. That being the case, let me caution everyone that people on the front lines, people who are working at healthcare providers, people who are working at financial institutions, if we're talking about whether a power of attorney will be honored, they do sometimes whatever their corporate legal department tells them to do, uh, whatever counsel to the hospital or healthcare provider tells them to do. And it may not be consistent with the laws that are on the books. So let's talk practically for a second. Not what
Okay.
the law is on your side. But practically speaking, if you encounter a third party who says, I'm sorry, that's an out of state document. I don't recognize it. We're not honoring it. And you say, well, I listened to Ken Gluckman's podcast and this guy was on there and he said you have to. So what's the problem? The problem is that getting other people to honor these documents, if they have a reason why they're not, you're probably not going to be successful, even if you're successful in getting directly in touch with their general counsel, which that doesn't happen anymore, right? They never let the general counsel identity out to the public. You communicate to the person on the front lines and they're going back to their general counsel, then they're going back to you. And it's a very difficult, challenging road to go down. You're probably going to have to go to court to enforce the out of state documents. How many people do you know that are going to be willing to pay thousands of dollars to hire a lawyer to say, see, I was right. You do have to honor my out of state power of attorney. So, that being the case, it's really actually less expensive in the long run to just have two sets of documents and you keep them in your back pocket. Whichever one you need to offer up, you offer up, and only if you have to rely on an out of state situation. For example, I'm working with a client now whose dad received care at Cleveland Clinic in Ohio, but he's a Florida resident and the son lives in Pennsylvania. So he had his dad flown to Pennsylvania for ongoing care, but it was a traumatic brain injury. His dad's incapacitated. And so, his Florida documents may or may not have been honored in Ohio, may or may not have been honored in Pennsylvania. It turns out he didn't even have any documents and we had to do guardianship. But to take this conversation full circle, any locations where you're going to spend significant time, probably a good idea to have a full set of advanced directives for those jurisdictions. So at least you're covered most of the time. Obviously, if you're traveling, I mean, you can really stretch this out to an extreme. So what if you're traveling abroad and you only
That was
have,
gonna be my next question about that. What happens if you're going to Greece like I just came back from?
yeah. So your family would have to offer up your
You're my
advanced
lawyer,
direct,
what do you do?
right, and hope that, because every time you travel, if you're a traveler, you're not going to get, you know, Greece documents and Portugal documents and Spain documents and France and England, and every country is going to have its own set of documents. So that's really taking it to an extreme. But I do think it's more reasonable and within reach to say, if I have children in my home state plus one or two or even three other states, and I know I'm going to spend significant amounts of time in those other states, that I'll have advanced directives so that I don't have the problem whether or not they're going to be honored. So let's see what else we can talk about. I think something that falls under the radar screen, and Ken, can you give me some idea of timing? How much time do we have today?
You're fine.
Okay. I want to talk about something that is not going to be inherent in the documents themselves, which is you, the person making out the document. It isn't the case that when you sign the documents, you're done, right? Because you need to have conversations with your agents. You need to really talk to them about your wishes and entertain scenarios openly and transparently so that they can really get some insight into the way you think about things, right? It's sort of like those commercials where, I don't know, it's like about parenting and that's like they encourage you to like, please talk to your kids about whatever, if it's drugs, if it's whatever. Um, Talk to your agents so that they have something that they can point to as a benchmark, as a reference point. What's important to you? Under what scenarios? Maybe you saw a movie, somebody was on life support, it resonated with you. You want to talk about that movie. You want to talk about circumstances and you want to talk about what your wishes would be if that ever happened to you. You're never going to be able to cover 100% of circumstances and decisions that this person's going to be asked to make. But certainly, you shouldn't just sign the documents, appoint them. They don't even know they're appointed. Or even if you say, hey, I appointed you, that's not the end of the discussion. That's the beginning of it. And I would
Exactly.
really encourage people listening today that if you already have the documents, if you're about to go and sign them, make sure that you couple the signing, which is really just the formal part of this, with the most important part, which is that whatever your wishes are, you've given your agent some insight. And there's another component to that, which is some people have either cultural and or religious requirements or preferences and desires that they want adhered to. That is another thing that you need to speak to with your agents. In some cases, there are some religious healthcare advanced directives where some instructions are spelled out very specifically. So you can discuss that with your attorney. Okay, so sometimes I'm asked, can I ever change my documents? I do them, but what if my wishes change? What if I want to change my agents? The answer is yes. They're revocable. They're at your will. And so if you're going to revoke the documents, let me tell you what you can do. Let me tell you what you can't do. You can't just say, I revoke the documents as you're walking around your home. You obviously have to revoke it in a
You
formal way.
can't say, "I'm disowning you," and that's it. You
Right.
have to have
You actually have
paperwork for
to
that.
execute on that and implement that decision. And so that requires a writing. I wouldn't just call up a bank and saying, hey, you know that power of attorney I gave you 5 years ago? Well, I'm revoking it. I mean, that might work, but that's not the way to go. Obviously, you need a formal written revocation of these advanced directives. And typically, if you do a new one, because you didn't want some of the appointees in the first one, there's a sentence in there that says, I hereby revoke all prior powers of attorney. I hereby revoke all prior healthcare proxies so that everybody knows this is the only one you should rely on. And then you go
That's
on
good
to
advice.
list who's going to act. I think that covers, for the most part, going, how do you go about appointing people in these documents? What are some best practices? Um, Ken, if you have any other questions, or I don't know if your audience is able to submit
No,
questions,
we
I'm
don't
happy
have
to.
that. We don't have them bother us. I mean, we don't have them call us, but they, they can send an email to us, contact us through our website if they want to. And we can give that information to you if you're interested in getting it. If there's somebody has a question, or I could send you an email with that question, and then we could
Sure.
respond to that person. The
Happy
other
to
question I
answer.
have for you, I don't disclose your business location. I mean, the name of your business unless you want me to, your .com, for example. Is that okay if I do that? And your office phone number?
Yeah,
I
sure.
mean, it may be beneficial. Of course, you may get me calling you, so it may not be beneficial, but
I
it's
love talking to you, Ken.
okay. So we can do that. Okay, let me just go through another couple of questions just to be on the um a lot of people, how much do these things cost? Because
So
initially when I did my initial stuff, I had an attorney who did our will, and he was in Florida, and things changed in our family, not a big deal. And then we had to go and get a living will. And then I read online that I can just print my own living will. And I did all the documents. And then I speak to someone such as yourself, and they say, well, that's fine that you have a living will, but that's probably not the best living will you're going to have. And then that question came up about what happens if we change states. Uh, so it's good to have advice, and it's good to have a professional such as yourself do it. What's the range of costs for these things? I know it's going to depend sometimes on the assets of the individual and how complex it is, but can you give me a range of what this would cost?
I'm sure I can. It's there are so many factors which I should probably go through first, and then I'll give you a range. Okay.
Okay, that's fair.
In Florida, there are 6 advanced directives. In Pennsylvania, there are 3. In New York, there are 4. So I think the number of advanced directives is probably going to play a role in the fees being charged. Number one.
Of course.
Number two, I think where you live geographically will play a role, right? If you're in a very high net worth neighborhood, the great likelihood is the fees are going to be higher than in perhaps a more rural and less well off, so to speak, financially neighborhood. So with all that being said, I mean, I think you could probably get advanced directives done for $300 to $500 on the lower end, and I'm sure that there are people charging $1,000 to $1,500 on the higher end, um, taking into account those two factors.
Okay. Anything else I should know about?
There's lots of
Not to
things you
call
should
you
know about,
directly
but
anymore?
what's that?
Is it not to call you directly anymore?
You can call me anytime, Ken.
Yeah, it was a good discussion, and I'm glad that you did most of the speaking because I get it. I don't want to say too much because I don't want to say the wrong thing. And I had one other thing that I wanted to add at the end about the quality of life and prolonging life. This was done by Best Endings Advanced Directives was where I got the quote. And I read a bunch of these things before I put them on the air. But this one I thought was very, very good for us. Two things. Sometimes the poorest man leaves his children the richest inheritance, which is why you should do the directives, correct?
For sure.
One reason. And the other one is for some, saving or prolonging life is what's most important. For others, quality of life is what's most important. It can be hard for people, including family and friends, to accept your choice. That's why it is so important to share your wishes, which is what you mentioned, in the decision making and share with everyone who matters to you. And that's how I would kind of like to end our discussion today, that you need to speak to the people that care the most about you, but you have to have this open discussion with them because they want to know what you think. And it's a hard thing to discuss, correct? I mean, if you and I sit down with our families and try to talk about this, it's not going to be necessarily a pleasant discussion.
It's not, well, I understand why people have a hesitation to talk about these things. But I'm going to give you a quote of my own.
That's good.
If
I like that.
you love your family, the greatest gift you can give them is to do this type of planning. And that is as self-serving a statement as I could make. So let me acknowledge that. But let me tell you why. If you don't, you're essentially leaving it up to their collective and individual ways of doing things, and perhaps without a rudder. That's why I think it is truly the greatest gift you can give them, because if you invest your time in speaking to them about it, as a group, there should be no doubt what your wishes were. Now, people may agree or disagree about what they thought they heard, of course, but making this effort truly is a gift that you're giving your family. And it really assures in most cases that what you want to happen will be carried out in a manner that is consistent with your preferences and desires. So I think it's good stuff. Not everybody takes the time to do it. I recognize that. It's a difficult topic, but a very important one. And I just, it's one of those head in the sand discussions. Just because you have your head in the sand doesn't mean it doesn't need to get done. And there are many, many rewards and benefits that come along with having these kinds of open discussions with your family.
You know what? It was a great interview that we had, and I want to appreciate you for taking the time and not billing me for this interview.
I told you, I wish I could.
Well, again, Howard, thank you very much. I'll call you Howie. Okay. I just want to give you a
Very good.
professional name, but I think you're more of a Howie to me, which is a name that
Absolutely.
I'm very fond of, my friend. And thank you again for being with me on the podcast today. Okay.
Thank
Thank
you
you.
for having me, Ken. Take
Okay.
care. Bye
You
now.
too. And that concludes this episode of We Are Old, Get Over It. Thanks for joining me. I hope you found our conversation both insightful and entertaining. Remember, age is a journey, not a destination. So embrace the wrinkles, the forgetfulness, and the occasional tech frustrations with a good dose of get over it attitude. Until next time, keep laughing, keep learning, and keep getting over it. Ken out.
This podcast features a variety of perspectives. The views and opinions expressed by our guests are solely their own and do not constitute an endorsement by this program. Unless otherwise stated, this podcast does not endorse the products and services of our guests, but shares them for informational purposes only.